Good morning. This is case 240845, State versus Gibbs. We have Mr. Webb Wasserman for the appellant, Mr. Gibbs, Ms. Gibbs, and we have David Banta for the state appellee. Mr. Wasserman, whenever you're ready.
Thank you, Your Honor. Be it please the court, counsel. The main issue that this court is going to have to decide here is how close this case is to State versus Cole. The Iowa Supreme Court decided Cole after Ms. Gibbs' trial, but before ruling on her motion and arrest of judgment and sentencing. The key question in a child endangerment case such as this is whether or not Ms. Gibbs knowingly acted in a manner that created a substantial risk to each of her children's physical, mental, or emotional health. And Cole addresses this issue in the context of what happens when you leave children home alone. Cole points out that not all risks are created by parents. The job of the parent is to manage the risks of ordinary life. And that the courts must exercise special caution in deciding whether or not a parent has created a risk that subjects them to criminal liability. Now, Cole identifies three different types of circumstances in which criminal liability attaches. The first is the parent's independently unlawful behavior. Now, the state here argues that neglect of a dependent person conviction, which was count one, for which the district court granted a deferred judgment, is independently unlawful. However, conviction does not meet the test of independently. It's based on the same facts and circumstances. It suffers from the same defects as the conviction for child endangerment. If you look at instruction 15, that defines what the elements that the jury was given here. And I think it's important to note what the district court did not decide in the sentencing transcript. There was an issue of whether or not the neglect of a dependent person conviction and the child endangerment conviction for the 7-year-old should merge. The district court decided it didn't need to decide that question because it was granting a deferred on count one, neglect of a dependent person, and therefore there wasn't a conviction there that needed a merger analysis.
So I hear where you're coming from on that. It sounds a lot like the bootstrapping problem, we talked about with Heemster with assault, and these are really the same crimes should they be merged together. But the Supreme Court didn't seem to care about that at all in its recitation of the rule in Cole. So are we really in a position to go outside the lines and come up with that now?
Well, I don't think Cole discusses merger between convictions at all. I think what
Independent crime rule with kind of no lines around it.
For example, Cole would address the situation, if you're manufacturing meth and you cause a fire and your child is injured, you've committed an independent criminal act that has caused that injury to the child and therefore are subject to liability for child endangerment. The district court here did suggest that it thought merger was a good argument, but it did not necessarily decide it. So, the court will have to decide if it needs to get to that and actually decide that issue based on what the briefing was in the district court on this.
Isn't there a possible framing, though, of that independently unlawful behavior that would fit this situation? Because it was the same conduct, but the fact that the middle child had the disability seems like it's a set of issues that could have possibly endangered the other two children with having to be responsive to emergency with that child. So it does seem like enough separate facts that it could stand alone.
Well, I think there's two kind of separate issues there. One is the effect on the 7-year-old, who is the special needs child, and then the effect on the other two children. I think those are somewhat separate issues. The merger issue, I think, goes to the 7-year-old. With respect to the other two, that was something that the district court had kind of come up with at sentencing about the risks to the children of having to deal with something happening to their brother while the mother was away and the emotional harm.
In response to the motion for judgment of acquittal, didn't she? I mean, it didn't arise first at sentencing.
There was an issue the district court talked about. I don't know, though, that the jury ever thought about that issue. There wasn't any argument to the jury along those lines in closing. Wasn't any evidence really about that. And there was
Jury instructions?
in the jury instructions.
Deals with emotional risk, right? Because that's what we're talking about.
Sort of like a general reference to emotional risk in the jury instructions and also in the closing argument of the prosecutor. But there's no specific argument that if something happens to the 7-year-old while the mother is away, that could cause some additional emotional harm of some type to the 9-year-old and the 4-year-old. One of the things that Cole talks about is that this additional risk that you're creating, there has to be a real possibility of that. And so I think that's the question here on this. Is this really speculation, or is there some real possibility? Because there's no evidence of this.
Police, though, coming and seeing that the child's 7-year-old's having problems. So, I mean, that seems very scary.
The question, though, is are any problems that the 7-year-old is exhibiting something different than he would be exhibiting if the mother had been there? That, I think, is what Cole talks about, is you have to be creating some sort of extraordinary additional risk by the behavior at issue that's leading to the child endangerment charge.
Easy to answer here because the mother presumably understands the suctioning equipment. She knows how to take care of her child, and there's no evidence that the other children know how to do that. Even the cops say that, they're spooked out of touching this thing.
Also, no evidence as to how often the child needs suctioning, what the effects of failing to suction the child on any particular schedule might be.
Cops saying that the kid had trouble breathing while they were there.
The same trouble breathing if the mother had been there. So, for example, like overnight when the mother's sleeping for like 8 hours, would the child be exhibiting the same issues? There was no evidence that the mother gets up every hour or 2 hours to suction the child. So one of the the features of this case is there was a very severe lack of evidence as to what effects anything might have on this child, and what the child's medical condition is, what his treatment needs to be. And under Cole, the question is, like I said, the additional substantial risk of some type created by the absence. So,
Here, and I think this is a difference from Cole, that the mother asked her friend to check in on the children.
well, basically, the evidence in Cole was that the neighbors were available, and they were not specifically asked on that particular occasion. So this case actually goes a little bit even further potentially than Cole, where the mother's asking people to check on the children.
Could that not cut both ways, that it was a recognition that the children needed some supervision?
Potentially, but we don't really have a whole lot of evidence as to what supervision the children would need. I think this case is very similar to Cole in that the neighbors are available. And in fact, Angel Wade does come over the second time the police knock on the door and answers the door. So she's there, she is available, just like the neighbor was available in Cole.
There's frantic follow-up here, the real distinction, because I read that as consciousness of guilt evidence. She knows that somebody needs to be in the house. She is texting, I guess we'll call it colorful language, to her friend, trying to make sure she's there watching the kids. Why isn't that evidence that she knew she was placing the children in substantial risk?
I think potentially that could be evidence of that. But really, I think under Cole, the question is, does the behavior actually create some kind of risk? In fact, I think the state even argues in its brief that the knowledge or intent isn't really relevant here.
Sure, that's right, because isn't knowingly an element of the crime?
Yeah, I suppose it is. This is not an issue that I've really thought about as to what the effect would be, but I do think that this case is close enough to Cole. One of the things I wanted to point out about Cole, it may not be too obvious, is that the Cole opinion does say that one of the children there is autistic, although noting that there wasn't any evidence as to what effect that might have on that child's ability to care for themselves. And similarly, in this case, with the 7-year-old, we do not have really specific evidence as to what kind of care he needs, other than he does have a feeding tube, he does have a suctioning machine, but we don't have information, particularly on the suctioning machine, which I think is where the state is largely basing its argument, as to how often he needs to be suctioned, what the effect of not suctioning him is, whether or not that causes any risk of death or other serious injury. So I see that my time is up here, so I will be back in rebuttal after you've heard from the state.
Mr. Banta?
May it please the court. This case is not like State versus Cole. The condition of the middle child in particular is the key point. And KG, using his nickname as an abbreviation, the 7-year-old child with special needs, KG's unique.
7-year-old out of here, is this Cole?
If you take KG out completely, I think this case starts to look a lot like Cole. And full candor before the court, if KG is not present here, then my argument becomes much more difficult. And it would have been framed totally differently. But KG is here, and that's the key part. And because of
A twist on that question. If we reject your argument about survivor's guilt related to like if something happened to the middle child, the emotional risk piece, if we reject that argument, do you lose?
because the argument is not just solely about survivor's guilt, the risk of something going wrong. The argument is also that SG and RG are too young, too little, and too vulnerable to be put in a condition where they have to safeguard and be responsible for their disabled brother. It's a serious thing to ask of a child. If you think of the sorts of conditions that Iowans face all the time of having a terminally ill parent, the amount of care that goes into caring for that individual is something that we would never ask of a child. We've never asked a 9-year-old to be responsible for a terminally ill person on oxygen who gets medication.
Presented to the jury, or did it need to be presented to the jury for us to consider it?
Specific theory does not have to be argued to the jury for this court to affirm on sufficiency. The question is, does the record give sufficient evidence for this court?
So is the answer that it wasn't presented, though, to the jury? The emotional, mental stress on the other siblings?
My recollection of closing arguments is that the state did not specifically argue emotional harm. The key point, though, is that the state didn't have to. The state does not have to advance all possible theories of the case for sufficiency review. It's never been a requirement, and it certainly isn't here. The key point is that the jury instructions included emotional harm. It wasn't just a passing reference. It's explicitly included in jury instructions 16, 17, and 18. There are instructions for each of the 3 children victims here. In each case, it's the third element at issue, which is physical, mental, emotional risk to health or safety. So that opens the door plenty wide for the state now on appeal to urge this court to affirm on the basis of a mental or emotional risk to health or safety. That risk is present for SG and RG, no doubt. It's more complicated for a child of KG's condition. The state didn't argue that KG suffered a mental or emotional harm because it's not clear what his mental or emotional capacity is. If there was a case involving an infant who was neglected for hours and hours and hours, just like this one, mom goes 100 miles away and has gone for more than 5 hours, but left an infant behind, if you're asking me on behalf of the state, I would say that physical risk there is the clear avenue. Because to what extent can an infant suffer mental or emotional harm? That's a harder question. Still, the state doesn't have to introduce expert witnesses to explain the condition of a child or have an expert talk about what care is needed. There is testimony in this record about KG's needs. He wears diapers. He has a feeding tube. He's immobile. He's sitting on a couch, propped up by pillows and blankets. He needs a suctioning machine to breathe. While no one said he gets suctioned every 2 hours or something like that, there is an officer watching over the course of 2 hours, standing in the apartment, and in the course of that 2 hours, an officer who happens to have been an advanced EMT previously, he sees KG stop breathing for at least 10 seconds. At that point, the officer says he's ready to call an ambulance, and the only reason he doesn't is because the sergeant there is talking to Gibbs, and Gibbs says that she'll be home very soon. But the officer there, who just happened to have medical training, wanted to call an ambulance because he was so concerned about the phlegm building up on KG's face. Specifically on this point, docket number 176 in trial transcript volume 3, pages 46 to 50, do a really great job explaining the physical distress that KG was experiencing. Now, physical distress is not a requirement under the statute, but it's certainly sufficient. It's risk that's criminalized. It's exposing children to risk that is the crime here. But in the course of that exposure, if they also suffer distress, the case becomes all the more clear. I'll talk about specifically what's on pages 46 to 50 quickly. KG had a coughing fit. He was congested. Phlegm covered his mouth and nose and bubbled on his face. Most importantly, he stopped breathing, like I said before, for at least 10 seconds. An officer who was an advanced EMT before watched and wanted to call the ambulance. If Gibbs had been there, things would have been absolutely different. There would have been someone there to suction his face and to clear his airways. The breathing is such a particular concern. It's not just that he wasn't changed for several hours. And while it's, to be frank, a shameful thing that he wasn't, it's probably not an endangerment case, the fact that his diaper wasn't changed. The fact that he went hungry for 5 hours, again, respectfully, it's probably a shameful thing, but it's probably not a criminal one under the endangerment statute. The criminal thing, I think, is the breathing problem. You can go 5 hours without having a changed diaper, without eating, even as a young, vulnerable child, but you cannot go for more than seconds or minutes without breathing. The risk that no one there could suction him is key to the physical risk that KG faced. I have an alternative argument, which is independently unlawful conduct. Cole makes it very clear there's no discussion of merger in Cole. Cole says a section other than 726.6. Neglect of a dependent person is a crime under 726.3. And to me, I think that you just follow what Cole says there, and it's very clear.
On that alternative, though, that seems sort of a separate element almost, or a separate way to prove that element.
Cole didn't exist at the time these jury instructions were made, so it wouldn't have been possible for anyone to foresee that. I don't think, though, that that is an element of child endangerment. Cole doesn't rewrite the statute that sets out the elements of child endangerment. It just explains how the Supreme Court views parent-created risks. And parent-created risks can occur in one of three ways. The first is independently unlawful conduct. The second is overt abuse. And the third is this identifiable risk. I think the easy way to shorthand it is extraordinary risk. Cole speaks of it as a substantial risk to physical health or safety that goes beyond the ordinary risks of life.
And I want to maybe go from there back to your earlier comments about what the jury was or was not told during closing argument. I'm looking at Ms. Slaughter's closing, and she talked about the word emotional, I think, 4 different times, and she casts it in the light of consciousness of guilt. She says, referring to Ms. Gibbs, she knew there's no way that you don't know that leaving children home alone. We're not talking about a gas station run. I need to go some milk. Instead, she's leaving the county. She's gone 1 hour and 53 minutes. Wasn't that argument presented to the jury about emotional risk when she keeps saying emotional risk in that context?
If that's what she said, absolutely, Your Honor. I don't cleanly recommend her using that word, but it sounds like you're looking at something in front of you that says she uses the word emotional.
The trial transcript.
That's a pretty reliable thing to go off of. If that's indeed in there, it's smooth sailing. This whole concern about does it have to be presented as a theory of the case? No, not at all. I would say though, defendants don't have to raise particular theories of the case to win sufficiency on appeal. If the evidence does not support the elements of the crime, even if it doesn't relate to any theory of the case that the defense relied on below, there could be a sufficiency challenge that's successful.
That the 3 child endangerment counts rise and fall on their own, each of them. They're not bundled together, they're not tied together. So even though the argument was made about emotional and mental, the theory that on appeal that the vulnerable sibling is what would have affected the emotional or mental state of the other siblings, that wasn't precisely drawn out at trial.
Permission, Your Honor, I'll answer your question over time. I agree that the state did not spell out the exact same argument in the contours that I'm making here. The fact that the state did not represent an emotional harm that was at the core of all 3 of them as a trial strategy doesn't undermine the state's theory now on appeal. It's sort of independent paths that can get to the same place. The 3 convictions do all stand on their own. They're just all bound up on this key fact that relates to KG's unique vulnerability. This court should affirm. Thank you.
Thank you, counsel. Mr. Wasmer?
First, I think it's kind of important to note that there was no evidence here as to what the 7-year-old's daily life is like. Does he sit on the couch for hours on end and having the same kinds of symptoms and conditions? You know, that there was no evidence that really talked about that.
And I agree that would be really nice evidence to have, but of course here we're stuck with sufficiency review. Every inference that is reasonable must be drawn in favor of upholding the verdict. So yeah, there's unanswered questions. I completely agree. How is that enough to get to a reversal?
Well, it's because the state here has the burden of proof and has to prove that there was some sort of extraordinary risk that was created by Ms. Gibbs being absent that the 7-year-old does not face on a daily basis. And so it was the state's burden to produce that kind of evidence, which they failed to do here.
Her statement's not enough to get there, where she's just frantically trying to get somebody at the house to watch the kids, and what seems to me like recognition, somebody needs to be there.
That appears to be more just, you know, the police are at my house, what are they doing at my house?
That's right, because before the cops get there, she's texting her friend, "Don't forget my kids, bitch, I'm already driving."
Yeah, I don't know that I have a great answer to your question. I haven't looked back recently enough at what she actually said and whether or not you can draw any kind of inferences from that.
That's the one we know is for sure before. The others are maybe a little murkier, like you suggest.
Kind of the more difficult hurdle for you is the fact that the officers are there and identifying a safety issue.
The question, though, is does he have those same kinds of issues on a regular basis when Ms. Gibbs or somebody else is present? I think that's kind of the key question under Cole. I think what Cole is trying to get at is you are trying to take, looking at, you know, okay, what are the ordinary risks of life, and what does a parent do to balance all of those risks? And, you know, they spend a good part of their opinion talking about things like, if you drive the kid to school, you know, you create a risk of being in an auto accident. If you let them walk to school, you create a different set of risks. So parents have to kind of balance those out. And so the question really here is, does her being absent for 5 or 6 hours create some sort of extraordinary risk that the children do not face on a daily basis? So, for example, with the emotional harm well, the idea of, the other two kids are watching the 7-year-old. When the police arrive, they're upstairs bedrooms, watching TV and a tablet. Well, is that what they normally do, even when somebody's in the house? There's no evidence they were given any responsibility for watching the 7-year-old. Specifically told you have to do this or that, to care for him.
Child, I mean, obviously she wasn't going to be left with no supervision safely in the house. It's like a battle to keep a toddler alive on a good day, right?
Different case, it was just the 4-year-old. Cole has a 5-year-old. We don't really have much evidence here, or any evidence as to what the difference between a 4-year-old and a 5-year-old. It might be different if we're talking about a 1-year-old or a 2-year-old. Because most people would say a 1-year-old or a 2-year-old are not capable of taking care of themselves on their own, and would have a high risk of getting into some kind of trouble if left alone. But with the 4-year-old, the only evidence you really have about her is when the police arrive, she's upstairs in her bedroom looking at her tablet. I think that's the sum and substance of the evidence about the 4-year-old that's in the record here.
Some evidence she might have been the kid that ran upstairs when the cops got to the door, but it's not super clear.
Not it was the 9-year-old or the 4-year-old that was kind of originally seen by the cops. I think they just said a child. I don't think they really specified male, female, age, anything like that. So I do want to comment on the independently unlawful thing under Cole. What Cole talks about in that context is basically that there's no Iowa statute that sets a minimum age for leaving children alone. So if you had a statute that said, a child must be 12 years old before you can leave them alone, and you left a child under the age of 12 alone, that would be independently unlawful. Here, with that merger issue, I just don't think Cole addresses that issue at all. So I don't think you can read anything about merger into Cole. Okay, I see my time is up, so thank you.
To both counsel for your very responsive arguments and your helpful briefing and helping us navigate what comes next after State versus Cole. We will consider this case 240845 State versus Gibbs submitted, and we will have a written decision as quickly as we can. And we will stand in recess until this afternoon.